Tonight, we're going to head to Washington with the nation's highest court preparing to hear a challenge to Obamacare. If the justices rule in favor of the challenges to the law, we're trying to prove that tax subsidies in some states are illegal. We're going to talk about what that could mean for millions of Americans who now rely on the new law. Well, tonight's show, everybody, it's dedicated just to the legal stuff. Exclusively our legal panel. It's hard to keep them quiet for 30 minutes, let alone 60. We're going to hear what they have to say, not just about that issue, but also how about asset forfeitures? The law says the cops can take your car, your money, your TV, even your house if they have reason to believe you're involved in criminal activity. Forget about going to court. And they can also seize your property even if you haven't been charged. Is this legal theft? Plus, it's being called the slap heard around the world. An altercation on the F train in the city caught on video. We're going to ask our panel how they believe the participants ought to be charged. You'll be surprised how the court saw this one.
Heavyweight champion. I
Breaking out all the special effects here. Good evening and welcome to RFL. I'm Richard French. Thanks so much for joining us. And tonight, we will begin in our nation's capital where the U.S. Supreme Court has agreed to hear a new challenge to the Affordable Care Act. Last week, the justice announced that they will look at one of the law's most important clauses. They'll review a part of the legislation that extends federal tax subsidies to Obamacare recipients in 36 states that do not have state-run exchanges. The feds, they set up the exchanges in those states where people can buy health care and receive subsidies. Credits, central part of the law, and if the high court actually rejects this clause, we're talking millions, maybe as many as 10 million Americans could lose their newfound health care coverage. At least 4 million people have already gotten subsidies to this point. Now, those who are eligible for subsidies paid an average of $82 a month, while those without help paid $346 per month, to give you a frame of reference. And about 87% of those who sign up for Obamacare plans on healthcare.gov receive the tax subsidies we're talking about. The Times puts it this way. The law says that subsidies should go to people who have brought coverage through, and this is the important clause here, quote, through an exchange established by the state, end quote, which the law's challengers say means that the tax credits cannot be used in the federally run marketplaces. All right, I want to bring in our table here. We're going to start on this and get to a whole bunch of subjects for the next 60 minutes. Jimmy Kasuris, criminal defense attorney in Manhattan, lecturing at New York Law School and a visiting professor at the University of Birmingham in England. Doug Von Oist, a founding partner of Carson Von Oist, focusing on corporate misconduct and selected by the Legal 500 as one of the most influential trial lawyers in our nation, and he graces us with his presence. Mayo Bartlett, attorney and former chief of the Vice Crimes Unit at the Westchester County DA's office, and there's a whole bunch of cases you're going to be seeing his name attached to. And Mark Furnish, professor of Brooklyn Law, and the only one at this table who's argued before the High Court, as he likes to remind us.
This is a much tougher audience.
Yes. Okay. Let's get into, I can do from the policy front, and then we'll do into the legal front. From the policy front, it surprised a whole lot of folks that the court took the case. We'll say for good or for bad, Mark, in a sec, but the consequences could be, as I said, different states took different tacks in it. Some basically said, you take over, feds, you take over and do these exchanges. Other states decided to run it themselves. They would not be impacted by this. But the states who do the exchange through the federal government and use these credits, they are definitely in play right now. And if you think about it, when you look at the political map on election night, you see all the reds and the blues. Trust me, there'll be disproportionate applications depending on where the colors fall on the map. This is a political issue. I'll save you a lot of time. The new Congress, with the now Republican majority in the Senate, they've already said they're going to try and repeal Obamacare for the 53rd time. Literally, it will go nowhere. However, you know how fervent some people hate this policy. And many people, that's at the root of where we are. All right, so I've done the policy front of it, Mark. Let's talk the legal. I've heard it that it's said that the intent of the law versus the language of the law is important here. I read that clause that was up there that's at issue here. The intent was never here. Many people believe that parsing that language, they said it's what's called a drafting error. Can you explain how one line in this omnibus thing here is now being examined and whether there's legitimacy to overturn the whole thing because of it?
Well, I don't think they're seeking to overturn the whole thing, first of all. I think they're setting up a future court challenge which could overturn the whole thing, but this case isn't going to do that. What you're referring to is a classic debate, jurisprudential debate between the plain meaning of the law on the one hand and the putative intent behind the law on the other hand. Now, I think it's difficult, and the textualist wing, literalist wing of the court also thinks it's difficult to plumb the intent of the people who wrote it, and they believe, the textualist wing, that the intent is what's written in the plain words. We don't go behind the words to figure out what they meant, and this bill, by all accounts, was passed quickly. They thought there was going to be a reconciliation of the bill between the House and Senate versions. None of that happened, so nobody really knows what the intent
Mark,
is.
don't we already know from the words of the justices themselves on related things that said they found out that, hey, maybe the hospitals, maybe the insurance companies didn't love it, but they all agreed the only way this thing would work was if there was buy-in and the feds operated these exchanges, and the tax credits had to be part of it. Everybody agreed that if this goes away, you're going to have all hell break loose in the meantime without any remedy. Secondarily, this court, though conservative, has always sided with business. The biggest businesses attached to this support this piece of legislation, maybe out of necessity, but they support it. Hasn't this already been asked and answered, whether it be in majority or even dissenting opinions?
I don't think so, because this is a different question. This is the question of the legitimacy of the subsidies if the states don't buy into it. And the plain meaning of the text in this case appears to conflict with the statutory interpretation that the IRS is giving the law. Now, normally you defer, or a court defers to the agency, the administering agency's expertise. I'm not sure that the IRS is truly the administering agency here.
But they clearly said that that was what they divined to be both the intent of it and the application.
Here's the thing, though. If their interpretation of it conflicts with the plain language of the statute, the court isn't going to defer to it, and that interpretation, I mean. And this is right in Scalia's wheelhouse, being the former administrative lawyer that he is and being the arch textualist that he is. Now, you combine that textualism with evident political opposition to this bill within the court, and this case is going to be, I think, very, very problematic for the people who are trying to defend it.
You guys surprised they took the case? Because for me, I thought this was already resolved. I mean, yes, politically it might not have been. This was certainly an election issue. I don't debate that. But we've had this fight for years before they finally got a vote. Why all of a sudden now, one straight line in this, we're trying to upend the whole thing? It just reeks of political, if not partisanship, whether it's fact or not, Jimmy. That's what it feels, and that's what it smells like.
Well, and that's what it is. I mean, what surprises me, it does surprise me that they took the case, but what surprises me is why this error, which has been in the lower courts for how long, wasn't corrected before this election. Because if there's a problem with this law, you're going to have a very hard time correcting it now. I mean, look, the legislature is presumed to mean what it says, on the one hand. On the other hand, when the option of opting out was a part of the law to begin with, it is inconceivable that the intent of the legislature was to deprive subsidies to those who went through the federal programs when the states opted out. So there's no question as to what was intended here. And that is the way I think they're going to rule. And the question is whether Judge Roberts, who was the savior last time, is going to be the savior this time, or whether he's somehow going to reverse course, which
here's the real end game here, what I think this is. You know, in the first big case, they decided that it was a legitimate exercise of the taxing power. They had a lot of negative things to say on 10th Amendment grounds, and the 10th Amendment means the federal government commanding state policy, commandeering it, and telling the states what to do. If the challengers win in this case, that will breathe fresh life into the 10th Amendment challenge that wasn't really rejected in the original case, because if the states have to opt in, do what the feds are telling them to do in order to get the subsidies, that's very, very close to the federal government commandeering the authority of the states and making policy for the states. And then I think the 10th Amendment challenge that was really ducked in the original case comes back to haunt the people who wrote this legislation.
But on the other hand, if the court finds that it's not fatal, then basically it solidifies the act. And it means that you're not going to have future challenges. And the court, and you know better than the rest of us, but it has a long history of doing things that, that defy the political makeup of its members. And I think that this would be an opportunity, because if you think about it.
Do you feel that way lately, though? Lately,
well,
it feels like you
certain
almost know where's Kennedy going to go. With the exception of that, almost everything goes according to form.
Occasionally, though, but when you look at searches of cell phones, you look at privacy, sometimes the court is not what we would anticipate. And in this case also, you look at equal treatment under the law. The subsidies come from a pool that all Americans pay into. So if you happen to live in one of these 34 states that didn't foresee the need or chose not to have its own provider from the state, you now don't get the subsidy that you basically paid for anyway.
Here's one thing that we should think about. As Jimmy pointed out, this case is not ripe. There's no circuit split. It hasn't percolated in the lower courts that long. They reached out to take this case. You need 4 votes to take it. I think sitting here, we know who the 4 votes are without making a real stretch. So it is going to be Roberts again in the swing. Presumably, since there's no conflict, it's not a mature circuit split, 4 justices reached out to take this. So it's already on pretty shaky ground.
Are they going to make people pay these subsidies back?
Look, I can't speak
I mean,
to the
that
policy.
would be
Listen,
effective.
the real simple thing for the non-attorney here, and I think the majority of you is, millions of people are going to lose health care out of this because of a stray line in there that all of a sudden some clever guy said, wait a second, maybe we've got the clause that we can do this off of. And I think whatever people feel, and there's certainly a conflicted American public on this legislation, my theory is the belief of the highest court, for all the bruising it takes here, this will be a big haymaker to it.
Well, here's the thing.
So,
maybe they knock it out, and then there's regime change, so to speak, and it's scrapped or modified by the next Congress.
regime change. Listen to him. All right, when we come back here, we're going to head over to the gridiron, where more attorneys are getting on the concussion lawsuit bandwagon. If you thought this was resolved last year, you haven't been paying attention. Could football be facing its 4th quarter here? Some fascinating questions as it all comes down to dollar and cents. And we'll weigh in on asset forfeiture, subject I'm looking most forward to talking about tonight here. Some calling it the practice of legal theft. Why should, I sound like one of these right-wing nuts here, but why should the government be able to seize your car here, TV cash, when you haven't been even charged for a crime? We'll get into that after this.